In this video, I'm going to explain to you about the necessity of consideration. Keperluan balasan. Why is it necessary to have consideration in a contract? This is because the general rule is that under Section 26, an agreement made without consideration is void. Here it means that if the agreement has no consideration, in that case, the agreement is not a binding contract. But we have exceptions to this general rule. There are situations where the contract is valid. The contract is binding, even though there is no consideration under the contract. This is provided under sections 26A, B, and C. Okay, the first exception is the contract which was made on account of natural love and affection. Kontrak yang dibuat berdasarkan kasih sayang semula jadi, provided under section 26A. This contract is valid even though there is no consideration, provided dengan syarat, first, it must be made in writing. Second, it must be registered. Ia mestilah didaftarkan mengikut undang-undang yang tertentu. And the third one, it is made on account of natural love and affection, kasih sayang semula jadi, between parties standing in near relation to each other. Near relation here, it means that the parties to the agreement having close relationship due to the family relationship or having blood related. But this, it depends on the personal law of each ethnic groups in Malaysia. For example, let's say the agreement is between the parents and the children and between siblings. So those can be considered as having near relation. Secara mudahnya, apa yang dimaksudkan dengan near relation ialah pihak-pihak yang berkontrak ini mempunyai pertalian darah atau hubungan ahli keluarga. So these conditions, if fulfilled, the agreement is binding even though without consideration. Okay, for example, let's say a father promised to give a house as a wedding gift to his daughter Siti. So this agreement is without consideration because when the father promised to give the house, there is nothing to be done by Siti as the consideration. So in this case, the agreement basically is not binding because there is no consideration. But since this agreement is made between parties standing in near relation, yang ada hubungan karib, maksudnya yang ada pertalian darah, blood relationship. So in this case, the agreement is binding even though without consideration. In contrast, in this example, Cindy make a promise to give a car as a birthday gift to Stella. And Stella here is Cindy's best friend. So in this situation, the agreement, basically there is no consideration and therefore it is not binding. And this agreement cannot fall under section 26A. Okay? Because it was not made on account of natural love and affection between parties standing in near relation. Walaupun Cindy tu mungkin betul-betul sayang sangat dengan kawan sahabat baik dia ni, tetapi because there is no blood relationship between Cindy and Stella, because they are just best friends, the agreement is not valid contract because there is no consideration and it was not made between parties standing in near relation. The second exception is the contract, the agreement which is to compensate a past voluntary act. Okay, satu perjanjian untuk memampaskan, memberi pampasan atas satu perbuatan yang lepas yang dilakukan secara sukarela. Okay, this is by virtue of section 26B, the first limb, okay, first part of this section. Okay, for example, let's say A here found B's wallet and returned it to him. Maybe A knows that the wallet belongs to B, so he voluntarily returned the wallet to B. So now B promised to give A 50 ringgit. This is a contract. After A has returned the wallet, now B make a promise to give A 50 ringgit. So why this is a contract? Even though there is no consideration, because this agreement is to compensate a past voluntary act. The agreement is binding. So there are two conditions for this exception. First, it is a promise to compensate the promisee, and the promisee has voluntarily done something for the promisor. So here, when A found this wallet and returned it to him, A voluntarily returning it to B. So in this situation, the second element has been fulfilled, right? So in that case, the agreement is binding. The promise to give A 50 ringgit is binding even though without consideration, because this agreement is to compensate a past voluntary act. The third exception is a contract to compensate for an act which the promisor was legally compellable to do. Okey, satu perjanjian untuk memampaskan atau memberi pampasan atas satu perbuatan yang mana perbuatan tersebut the promisor, yang sepatutnya promisor melakukannya tapi dia tak buat, yang melakukannya ialah promisi, and it was done in the past. Okay, the agreement is binding even though without consideration. Okay, for example, A supported or looked after B's infant son, and then B promises to pay A's expenses in so doing. So this is a contract. Now, to explain this clearer, okay, let's say here, okay, B here having a son. So under the law, B should look after the son, right? However, B neglected the son. Dia abaikan, dia tinggalkan anak dia tanpa sebarang maintenance, okay, to support the son. So now what happened? A, mungkin jiran dia ataupun his friend, voluntarily supported B's son. Okay, dia secara sukarela jaga anak B. Now, let's say after 20 years, B then return to A, then they make a promise to pay 50,000 to A as a compensation for A's past act, which is done voluntarily supporting his son for the past 20 years. Okay, the question is there any consideration for this promise? Does A has to do anything for this promise? No, right? Meaning there is no consideration for B's promise paying 50,000 to A. However, since this is a promise to compensate a past voluntary act which was done by A, okay, and which such act sepatutnya siapa yang buat? Sepatutnya B yang jaga anak dia. Tapi yang jaganya siapa? A. So in that case, this promise is binding upon B. In that case, B has to pay A 50,000. Even though this agreement is without consideration, it is a binding contract. There are three conditions to be met. First, there is an agreement to compensate the promisee. Ada perjanjian antara A dengan B tadi, right? Where B, dia promise to pay A. The promisee has done the act voluntarily. A, dia jaga anak B tadi secara voluntarily, secara sukarela. Dia tak minta pun apa-apa balasan. Okay? Not upon the request of the promisor. Promisor tak minta tolong pun. Tiba promisee yang sendirinya voluntarily look after B's son. Okay? Jaga anak B. The act done is one which the promisor was legally compellable to do. Sepatutnya yang menjaga anaknya secara di sisi undang-undang adalah B, which can be compelled. Alright, yang boleh dipaksa dari segi undang-undang untuk menjaga anaknya adalah B. Tetapi it was done by A. So if these three conditions fulfilled, in that case, the agreement to compensate a past voluntary act is binding even though without consideration from the promisee. Now, the fourth exception is that a contract to pay a statute barred debt. Satu perjanjian untuk membayar satu hutang yang telah dihalang oleh statute. Statute barred debt, hutang yang dah tersekat oleh statute, oleh undang-undang. What is the statute barred debt? Here it means that it is a debt which cannot be recovered through legal action. Okay, yang tak boleh lagi nak dituntut melalui tuntutan mahkamah ataupun undang-undang because of lapse of time fixed by law, sebabkan dah luput tempoh yang ditetapkan oleh undang-undang, iaitu 6 years. Okay, this is by virtue of the statute. Apa statute dia? Limitation Ordinance 1953. Under this ordinance, it is provided that the limit for the creditor to claim his debt towards the debtor is only within 6 years. So maknanya dia kena tuntut hutang dia daripada penghutang, okay, dalam tempoh 6 tahun. After 6 years, automatically the debt is no longer recoverable. So the creditor can no longer claim for the debt through the court of law because it was lapsed. It was statute barred debt. Dah dihalang oleh statute, that is Limitation Ordinance 1953. However, if the debtor, ni penghutang sendiri, makes a new agreement. The debtor himself makes a new promise to pay the debt. So this new agreement becomes a valid contract under section 26C. This agreement is binding even though without consideration. Right. And provided there are two conditions to be met. First, the debtor made a fresh promise to pay the statute barred debt. Second, the promise is in writing and signed by the debtor or his authorized agent. So maknanya kat sini, kalau promise tu dibuat oleh debtor sendiri, okay, and the promise is to pay the statute barred debt, hutang yang dah luput tu. In the first place, the creditor dah tak boleh nak claim apa-apa sebab the debt is already statute barred, dah dihalang oleh statute, dah dihalang oleh undang-undang. Maknanya dia dah tak boleh claim, kena redha je lah. Right? Okay, tapi since the debtor sendiri yang made a fresh promise, dia tahu dia kena bayar juga hutang dia. So kat sini debtor yang made a fresh promise to pay the statute barred debt. And that promise is in writing and signed by the debtor or his representative. So in this case, the agreement by the debtor is binding even though without consideration from the creditor. So those are the exceptions to the necessity of consideration. Under the general rule, the agreement is void if the agreement has no consideration. It is not binding. However, under these four exceptions, okay, the agreements are binding and valid even though without consideration, provided fulfill all the conditions required under the provisions.